Good morning to those of you joining us from the Americas, and good afternoon to those of you joining us from the EMEA region. My name is Mark Lightner, and among other things, I head up the Special Situations Legal Research here at CreditSights, and I have the privilege of hosting today's panel entitled Cooperation Agreements and Antitrust, the Next Major Battle. As many of you know, cooperation agreements, which we also refer to as co-ops, are commonplace in the distressed world and are utilized by creditors to work together to protect their common interests within the context of out-of-court debt restructurings. There have been two recent lawsuits filed, which are both pending in the Southern District of New York, challenging co-ops on antitrust grounds. And these lawsuits have given the restructuring community a fair amount of heartburn. The first involves a company known as Optimum, formerly known as Altice USA, where the company itself is suing its creditors for organizing and entering into a co-op. The second involves a company known as Selecta, where one group of creditors who were excluded from participating in a co-op are suing the group of creditors that did not join the co-op. It is against this backdrop and the prevalence of co-ops in the restructuring community more generally that we've put together a panel of experts who I will introduce in just a moment to explore a number of important topics at the intersection of cooperation agreements and antitrust law. Let's take a look at today's agenda. We're going to take a look at liability management transactions or liability management exercises briefly and how cooperation agreements interact with those concepts. Next, we're going to talk about the two cases I recently mentioned, Optimum and Selecta. We're going to look at what those cases are all about, what the facts are, what the issues are that have been raised, and who the parties are and what they are seeking in terms of relief. In addition, we will talk about how the courts are likely to assess cooperation agreements under antitrust laws, and we're going to look at some of the arguments that we expect the parties to make for and against antitrust liability. Finally, we're going to consider potential judicial outcomes and the market's current response to those lawsuits and what, if any, behavioral changes we are seeing in the marketplace. Now, I'd like to take a few seconds to introduce our panel. To my immediate right on the virtual screen is Feng. Ian is a senior covenant analyst at Covenant Review and is a well-known expert on liability management transactions. If you don't know Covenant Review is the market-leading expert on bond and load covenants and is a fit solutions company that sits underneath the CreditSights umbrella. Next to Ian, we have Dan Kamensky. Dan is the managing partner of Restructuring Law Advisor, where he advises clients in restructuring and distressed situations. He is also the founder of the Creditor Rights Coalition, which distributes the Creditor Corner, to over 3,500 restructuring professionals on a weekly basis. If you do not receive this newsletter, I encourage you to visit their website at www.creditorcoalition.org. I can say from personal experience, I enjoy reading that newsletter every Sunday morning. Next to Dan, we have Jeremy Calcine. Jeremy is an antitrust partner in the Washington, D.C. office of Cleary, Gottlieb, Steen, and Hamilton. Jeremy joined Cleary in 1999 after a clerkship on the U.S. District Court for the District of Columbia and has been an antitrust partner at Cleary for the last 18 years. Finally, but certainly not least, we have Sean O'Neill. Sean is a restructuring partner in the New York office of Cleary, Gottlieb, Steen, and Hamilton, where he's been a partner for the last 17 years. Sean, like Dan, is a returning panelist, and we love having both of them with us today, and I'd like to thank them for being here. If you'd like to see additional information about any of our panelists, we have included their LinkedIn bios within the webinar browser, so please feel free to reach out, connect, or follow any one of us. Finally, I have three short housekeeping items before we get started. First, you can submit questions into the webinar itself. As you can expect, we have a very large audience today, and we will do our best to address them. If we do not address your specific questions, we will reach out offline either this afternoon or tomorrow. Second, we will make the slides available if you reach out to us through this platform, either to us directly or through our events team email, which can be found on the registration page. And finally, today's recording will be available for replay on our recently created YouTube channel, which we encourage you to subscribe. It's also really great because Gemini is fully integrated into YouTube and you can get summaries and you can interact and ask questions about what we talked about today. So without further ado, I'd like to pull in Ian Feng from Covenant Review to give us an overview of what liability management transactions are and how they interact with cooperation agreements. Ian?
Thanks so much, Mark. And good morning or good afternoon to everyone on the webinar today. Um, so the conversation today is about co-op agreements, and we're really talking about it in the context of liability management exercise or liability management transactions. And so the question that should be asked is, well, what do we mean by an LMT? And unfortunately, there is no formal definition. You ask, I think, any restructuring partner at a different at any law firm or restructuring practitioner, and you're probably going to get slightly different answers from each one. That being said, the way that Covenant Review defines it is as a distressed transaction using existing or amended contract terms to manage long-term debt, and most importantly, with creative out-of-court solutions. And it's that key term creative that I think really distinguishes LMTs from more traditional out-of-court restructurings and things that we would think of as out-of-court restructurings, let's say 10 or 15 years ago. So today, when we talk about an LMT, we're usually talking about something that will change the relative priority of debt holders, i.e. a up tier, value transfers, sometimes called drop downs, usually utilizing some kind of non-guarantor flexibility. It might be competing creditor groups, and you'll hear the term lender on lender violence sometimes. And most importantly, again, the deviation from that traditional or historic expectation that a creditor has when he or she enters the deal. So when you think about a Serta or a J. Crew, what made them notable was that they broke certain expectations of those creditors that they didn't think could be broken. And that could be collateral value or their relative ranking. If you look at the chart to the right, you'll notice that LMTs has become quite common over the last, let's say, 5 or 6 years. Certainly in the last 2 years, they've become, if not the preferred, then a very much important avenue for a lot of distressed companies when it comes to managing their debt. Next slide, please. I think Mark gave a really good overview of what a co-op agreement is. It's essentially the response to it's a response to the rise of liability management. And unfortunately for a lot of lenders, LMTs have had the effect of weakening their position, and often they're in a position where they're quite unhappy. So think again, J. Crew, your collateral is stripped. Serta, you have been subordinated from first lien to third lien or fourth lien or something like that. The response was that creditors decided that the best way to approach LMTs or distress scenarios in general was to combine, to form together as a block so that they could best negotiate against a aggressive sponsor or a borrower, and thus co-ops were born. Now, co-ops come in a couple of different flavors. We have some here. The inclusive flavor of co-ops are those that try to encompass as many creditors as possible. And this can be across different debt classes and instruments. So term loan lenders as well as bondholders could potentially be in the same co-op. And again, this is designed to establish as strong a negotiating position as possible for the creditors against a particular issuer or borrower. Then you have exclusive co-ops, which are slightly different because they're not designed to bring on everyone into the co-op group, but really just a portion of the creditor pool. And that's designed so that they can best maximize the value in the deal that they're negotiating with a particular borrower, perhaps at the expense of those who are left out. And then you have tiered co-ops, which are not really a separate flavor. You can have a tiered inclusive co-op or a tiered exclusive co-op. It merely refers to a co-op agreement where signatories are treated differently in terms of economics and or other rights or privileges. So a common example here would be um, uh, backstop premiums or backstop fees that might only go to, let's say, a steer co or to a specific subset of the ad hoc group rather than to everybody. Next slide, please. The response to co-ops in general have been, I think, at best ambivalent. And the reason I say that is that cooperation is not necessarily a bad thing for all parties involved, right? There is an argument that co-op agreements and co-ops in general can facilitate the negotiation of LMTs or restructuring as a whole. More than that, a lot of sponsors, especially large financial sponsors and private equity firms, also tend to play on both sides of the market here. So they're not just a sponsor, but they are also potentially a lender through a major credit arm, for example. And so the first main response to co-op agreements that we've seen in the last, let's say, 18 months has been this idea of an anti-cooperation provision. And these are clauses that are implemented into new issue debt, so in the syndication phase, and are designed to inhibit, but not necessarily truly prohibit co-op agreements. And the way they do that is they'll be drafted in a way that says that co-op agreements are not allowed unless the company otherwise consents. And that's very much designed to control the LMT process. So if you can get an anti-co-op provision into a credit agreement or an indenture, then the expectation is that the issuer or borrower will have control over the negotiation of an LMT because they can decide who's actually in that co-op group. Now, anti-cooperation provisions have tended to be relatively muted in how they can punish particular lenders who violate them. Usually, disenfranchisement or disqualification are the main consequences, which means that you can't vote if you sign a co-op, or maybe you get disqualified and therefore yanked. But again, it's not really designed to be that punitive. There is one exception, of course, and that's Optimum's credit agreement that was disclosed back in November of last year. It's an unrestricted subsidiary credit agreement. In that particular anti-cooperation provision, lenders who sign a co-op are in fact forced to forfeit their right to repayment. So their debt is effectively canceled. Now, broadly speaking, anti-co-op provisions have not cleared the market. The buy side has, for the most part, drawn a red line when it comes to these kinds of provisions. It is one of those few provisions that they will absolutely refuse to allow to clear the market, and that's what we've seen. Any new issue document that has an anti-co-op provision in it has seen that ACP flexed out, either in syndication or even at the early look phase. Again, one of the two major exceptions being Optimum, the other being Warner Brothers Discovery in the summer of last year. Neither of those are traditional syndicated loans, so not really. They're more of an outlier in that regard. Next slide.
Thank you, Ian. That was a really helpful table setting before we get into the meat and potatoes of today's discussion. But before I bring in our friends from Cleary Gottlieb, I thought it would be really helpful to get kind of a market reaction about how we view collectively cooperation agreements. So we have an audience poll that I'd like everyone to take a second to respond to, which is, are cooperation agreements in restructuring situations A, net positive, i.e. facilitating restructuring and create value, B, net negative, impede restructuring and destroy value, or C, neutral, no strong opinion. So we'll give folks who are listening in a few seconds to submit responses, and then we will see the results for the group. This is helpful for us to kind of take the temperature of the market, because people have a lot of strong feelings on cooperation agreements on both sides. So we have a number of responses. We'll give it just 5 more seconds or so, and then we'll take a look at the responses here. Interesting. Almost 2/3 of the group view co-ops as a net positive, and they facilitate restructuring and create value. That's a really interesting lead-in to some of the antitrust issues that our friends from Cleary Gottlieb are going to talk about. So, Jeremy, I'd like to bring you in here to kind of walk us through these two lawsuits that have been filed, and to educate our audience about what's going on here.
Great. Thanks, Mark. Yeah, we've got two interesting lawsuits. I think they get lumped together, but there are some pretty important distinctions between the two. So we've talked a bit about the Optimum case already. It's used to be known as Altice. They've got a large $26 billion in total debt, and some of their creditors formed a co-op agreement. And the allegations in the complaint are that co-op covered approximately 99% of Optimum's debt across all of its series. They filed in the Southern District of New York, and they have some pretty strong allegations that say that the co-op is a classic illegal cartel that is, per se illegal. And we'll talk a little bit more about what that means. And basically, they point to the fact that the co-op prevents any co-op lender from dealing with the company without the approval of holders of 2/3 of the debt held by all co-op lenders. And that's important because I think the lending documents actually provided for a simple majority rather than 2/3. And we'll talk about why that might matter here. On the other hand, we've got kind of from a different angle, the Selectum case where um, I'm sorry, we'll stick with this. So, in Optimum, they said that the lenders were acting as an illegal cartel that fixed the terms and pricing of debt transactions for them, and that this drives up the prices for all loans from funding sources outside of the co-op group, and keeps the company from repurchasing or refinancing its own debt at market prices. I want to point out here that what they argue two markets: one, a market for all leverage finance instruments, and two, a market, an antitrust market just for Optimum's debt. So those are the price fixing allegations. Essentially, it's a classic cartel. The lenders are working together to set the price, and that is allegedly illegal. They also have group boycott allegations, which say that these agreements keep the creditors from transacting with Optimum without the supermajority 2/3 approval. And they allege in their complaint that that's kept them from being able to have any substantive debt negotiations with individual members. Now, Selecta, I jumped the gun on that one, but Selecta is a little bit different here. We've got Selecta is the company, a European company that had a multi-step restructuring that resulted in preferential treatment for a majority group of their creditors. And the favored holders entered into a co-op in April last year, and they agreed not to support any further restructuring transactions unless the co-op lenders were allowed to participate pro rata, and no rata interest was adversely affected. So just for the members, not to transfer any non-acceding transferees, and not to amend the co-op without 100% consent. So here, the plaintiff is the plaintiffs are minority lenders who were not did not participate in the public exchange, and they filed against Selecta and the favored holders. So here you've got a lender who was kind of left out of the co-op, saying that the co-op excluded them from participating and that they were harmed by that. So they challenged the co-op on antitrust grounds and various theories of breach in connection with the restructuring. And they've got similar price fixing allegations and group boycott allegations, although instead of the borrower against the co-op, this is a minority lender against the co-op. Now here, again, the market definition is a little different. They essentially define a very narrow market of first lien holders. And so this is quite a bit different and very narrow. And essentially they're saying, this market is narrow because that these favored co-op holders excluded us, and as a result we're harmed. And I think what they'll say is you can tell that we were harmed because you can look at the price of the um, the public exchange, the new debt instrument versus what they're holding now. So what are the differences? Optimum, I've touched on these already, but Optimum suing its creditors, and they're seeking treble damages, attorney's fees, and a declaration that the co-op is unlawful and void. And Selecta, the disfavored minority creditors, are suing the majority creditors for keeping them out of the first lien debt, from the opportunity of owning first lien debt. Selecta is seeking monetary damages, statutory treble damages. All of these antitrust cases, just to kind of step back for a second, if you're able to prove liability, so prove that the defendants are liable, then the jury or the court is asked to determine what the harm was caused by the violation. And if antitrust claims, the ones here, are automatically trebled. So you take, you say there's $10 million of harm, that's automatically trebled to $30 million, and there's joint and several liability against all defendants. And if the plaintiff has proved liability, they also get attorney's fees. And here Select is also saying they should get interest as well. So this is pretty interesting. I guess I'll open it up a little bit to any other panelists if they want to chime in. But I think, if you're on the Optimum side, kind of what do they really want? I think they want to break up the co-op and, be able to negotiate on their own terms. And maybe they will try to press this forward if they're unable to do that and seek damages and to do it. What they'd like to do is get back into the favored uh, co-op and get the benefit of what was bargained for there. So, Mark, I'll kick it back to you.
Sure. That's a very helpful background on these cases. And before we get into a discussion of the legal issues and some of the arguments and defenses, we thought it would be helpful to poll the audience to see, what you're hearing in the market and what you think is ultimately going to happen in these cases. So we have two poll questions, one after another. First, we're going to ask you, how do you think the court will ultimately rule in the Optimum case regarding the legality of the cooperation agreements? And again, this is the case where the borrower is suing all of the creditors who have entered into the co-op. So, uh, A, the court will find for the plaintiff the agreement was unlawful under antitrust law. B, the court will find against the plaintiff, i.e., the agreement's upheld as lawful. Or C, too soon to tell, uncertain. If folks could submit their answers, we'll poll the market and see where we think we are today. So let's just give folks a couple more seconds here. We're getting quite a number of responses. Let's see. Okay, let's see. Interesting. So only 7% of the market thinks that the court is going to find for the plaintiff. That's very interesting. Whereas almost 60%, 56.8, said the court will find against the plaintiff, and roughly a third will say it's too soon to tell or uncertain. Now I'm going to ask the same question about what folks are thinking or potentially hearing in the market with respect to Selecta. Selecta, again, is the lawsuit where the excluded lenders are suing the co-op lenders. So the question is, how do you think the court will ultimately rule in the Selecta case regarding the legality of the cooperation agreements? A, the court will find for the plaintiffs, i.e., the agreements found unlawful under antitrust law. B, the court will find against the plaintiffs, the agreements upheld as lawful. Or C, too soon to tell, uncertain, right? So we've got these two different cases, different fact patterns, different plaintiffs. We've heard a lot of different things in the market about the differences, and people have strong feelings about both of them. So let's see what the market thinks about this and see if there's any difference. One more second, we'll get a few more responses. We have quite a few already. Okay. Interesting. This one says the court will find for the plaintiffs. And 30%, the court will find against the plaintiffs 40%, and it's too soon to tell, roughly a third. So we see a significant difference in the number of people that think the plaintiffs will win, going from roughly 5% to 30% in the Selecta case. So that's very interesting going forward. So, Jeremy, if I could bring you back in here to talk about the legal framework, because I think a lot of people, a lot of smart people on the phone today may play antitrust lawyers on TV, but it would be really helpful to get an expert's perspective. So I'll turn it back to you.
That's great. I love these polls. So what are we dealing with here? We're dealing with the Sherman Act, and that basically has very broad language. It says every contract, combination, or conspiracy that restrains trade is declared to be illegal. Obviously, every contract has some restraint in it, so the courts have interpreted the statute to kind of require some other kind of created two frameworks for how to analyze antitrust claims. So the first is the per se violation framework. So this is where you basically say, was there an agreement? Yes, it's per se illegal. We don't really need to go any farther than that. And where you see per se illegal cases is where courts have seen they've developed considerable experience with the type of restraint, and they basically have found that these types of agreements always harm competition. So price fixing, naked bid rigging, market allocation, this is presumed to harm competition, and you don't have to prove the harm other than in the damages phase. So that's just basically if you prove the agreement, you've established liability, and you go forward to a damages phase. Rule of reason cases are for potentially legitimate agreements where legality depends on the circumstances. So the courts in these cases will conduct a balancing test, and they'll look at the allegations. Is there a properly defined relevant market? And that's why we talked about first lien versus kind of all finances. Market power. Did the you know did do the is market power involved in the folks who have the agreement? Anti-competitive conduct. Was there harm to competition? And that's important. I'll talk about it in a minute. And antitrust injury to the plaintiff. These two factors are really important, I think, in these cases, because it's not just that there's an injury to the individual plaintiff. It has to be an antitrust injury. So does it harm competition? Did the agreement harm actual competition in a well-defined market? So what are the arguments? Liability. I think on both Optimum and Selecta, I think there will be arguments by the defendants that say this should not be a per se case. Co-ops have not been shown to be universally harmful, and I'll talk about this in a few slides. But there's actually court precedent that's show in the Second Circuit and the Seventh Circuit that co-ops actually are can be legitimate. So it seems hard to take a situation where you've got that precedent and now say, oh, it's automatically per se illegal. Collective action is fundamental to the debtor-creditor relationship, and even if you look at the Optimum case where it talks about a majority acting, there's typically these agreements do require creditors holding a significant percentage to act together. So again, it doesn't seem like a per se type of a case. And then I think there's court precedent that borrowers and creditors benefit from the existence of co-ops. That as Ian mentioned, anti-cooperation provisions generally have failed to clear the market, and co-ops can resolve intercreditor issues. And as I mentioned, the Second Circuit has said joint activity by creditors facing a debtor is commonly in the interest of all parties. So these are pretty fact-specific questions, but to me, it seems very difficult for a court to apply a per se analysis to either of these cases, given the nature of the agreements and given and the relationship between the creditors and the lenders, and the creditors and the borrower, and given the precedent that's out there.
Jeremy, I think it's really interesting that what you just described is entirely consistent with the audience's response about whether co-ops are positive or negative. So I think that's a really interesting comparison.
Yeah, that was great for me because like I said, I'm loving these surveys. It's really interesting to see what the audience has to say.
Yeah, and
So
I would just add, Jeremy, that I think one of the big elements the courts have looked to is in terms of the benefit of the co-op agreement is really the transaction cost, the lowering of transaction costs, making it easier to negotiate with creditors, and collective action is embedded in debtor-creditor relations and debtor-creditor law. We rely on collective action in credit documentation and the law itself. So it reduces transaction costs, and then therefore, I think the argument is that it reduces borrowing cost as well.
that's great. So what other defenses? I mean, well, they'll argue that per se doesn't apply. So then you follow into a rule of reason, and what kind of defenses do you expect to be made? So we've talked about the market definition. I think the defendants will say the plaintiffs in both cases have not alleged a proper antitrust market. So, uh, I think the defendants will say in Selecta that look, this is all prediction. I could be wrong, but that the first lien market is too narrowly defined and ignores competition from other types of credit. And I think in Optimum, they'll say that just looking at Optimum's credit as a market is too narrow as well. And it's kind of interesting. Everything's happening in real time here. Optimum, has obtained $1 billion in asset-backed financing and $2 billion in incremental term loans at an unrestricted subsidiary after the co-op group formed. So I suspect that the defendants will point to that to say, look, this co-op is not either the market's they'll use it for different things. But I think first, the market's broader than just what's been alleged in the complaint. And then second, this co-op is not tied up Optimum. They've been able to get funding from other sources.
Yeah, and
Um,
Jeremy, on that note, I would just say that just yesterday, Optimum announced that the incremental, a $1.1 billion incremental, I think replacing the initial 1.1 billion. So the market is still there. It was placed in, it's a private credit facility, as Ian noted, not involving co-op members, but I think that's going to be a big aspect of the defense in this particular case.
Select is a little different because they've narrowly defined it as the first lien debt, and so you can see the excluded lenders saying, we're only talking about this very narrow market. This is where we hold. This is where the paper is, and these other options really aren't there for us because this is where the facts don't support being able to go out and just simply exchange into something else. So we'll have to see how that market definition point comes across in the papers. And then the challenge conduct's not anti-competitive, and I think Sean touched on one of the main reasons for this, and courts have also recognized that there are good reasons for these. Other things I think we'll see in the defenses, in Selecta, I would think that the defendants might say, why is this case appropriate for the U.S. courts? This is a non-U.S. lender, and this is the restructuring occurs abroad. So, should this really be in the U.S. courts under the Foreign Trade Antitrust Improvements Act? That's a kind of a very technical argument, but it is pretty unique to Selecta. And then
And to be
Optimum, I
clear
think,
too, Jeremy, that's an antitrust issue. It's not just simply the normal jurisdictional questions that we deal with every day. It's a specific antitrust extraterritoriality exception.
yeah, that's a great point. Yeah, so the plaintiffs will have to effect on interstate commerce or import commerce with the U.S. And so I think when you look at the allegations, that's going to be, if I were on the defense side, I would point to that. On the Optimum side, I think that the no antitrust harm here to the plaintiffs is going to be an argument that the defendants rely on, and I think a lot of what we've already talked about ties into that. I can see that issue being raised in Selecta as well. That you're talking about some excluded lenders. You're not talking about actually a harm to competition. This is really just a fight between companies, that doesn't really affect competition. So we mentioned the bankruptcy precedents. I think United Airlines is a very important case in the Seventh Circuit. So where the court said that cooperation in an effort to collect as much as possible under competitively determined contracts is not the sort of activity with which the antitrust laws are concerned. CompuCredit is a really interesting case where creditors coordinate to maximize their ability to collect an outstanding debt cannot be an antitrust violation. I think, if you read those cases, you see a difference between kind of the court saying, this is just not kind of the initial decision to issue to provide financing. This is actually trying to work out kind of financing that's already been delivered, and that's I think an important distinguishing characteristic here. I think the plaintiffs, though, have some good ways to distinguish those cases. In United, it was actually a bankruptcy process, and there was judicially created Nor Pennington defense, where joint petitioning of a court is protected. And here, I think the plaintiffs would say, well, we're not in a bankruptcy situation, so Nor Pennington doesn't apply, and therefore you should take the broad statements about kind of whether courts and antitrust laws should be concerned with these issues with a grain of salt. And I think the others will say, kind of when you look at CompuCredit, and I think the plaintiffs will say, this is they are covering a broader range of activity and than just collecting on an existing debt. And in fact, they're kind of, I think in Optimum, they will say, you're not just kind of collecting the existing debt, you're kind of reworking the terms of the existing debt, kind of moving from a simple majority to 2/3 is kind of one fact that I think they would probably rely on.
And Jeremy, if I could just follow up on that, the Norr-Pennington doctrine that's from the 1960s, it deals with a couple of railroad situations. And basically what it says is it protects First Amendment rights to petition the government. And so, a judicial proceeding is considered the government. In terms of that second point that you made, I think that the 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 existence of language in the co-op agreement, which is very typical in co-op agreements that say that you as a member of the co-op will not do a transaction away from the group. I think that's really the central focus or one of the central focuses in the lawsuit. I think they're really going to hit that one hard, which is, the limiting the ability of co-op members to do any transaction with the debtor away from the group. Thank you.
Agreed. So let's talk a little bit about the judges. So I think I liked all the predictions in the questionnaires, the surveys that went out. So we've got Judge Otkin in the Southern District. He's been a judge for a long time, very careful judge, worked on the Supreme Court. And we've got Judge Vargas. She's a newer judge, but very experienced and have a less of a track record on antitrust cases, but also clerked on the Supreme Court. I think both of them will be very careful in analyzing these things and considering the precedent. And I think when you think about what's the schedule, when are we going to know? Because as things are happening in real time, it's, the courts sometimes can move fairly slowly. So, initial motions to dismiss, we'll have the Selecta one in a couple of weeks, the end of January, Optimum a week later. And then Optimum kind of has its pre-trial conference, and the oppositions and replies to the motions to dismiss are kind of on similar timelines here. So even though we've got two very different cases, we may have fully brief motions to dismiss by the end of April. We'll have to see if the courts schedule argument on the motions or if they just decide them on the papers. Of course, the timing of when a judge decides a motion to dismiss is uncertain. It could be many, many months. You could get a read on it based on based on an oral argument and kind of feedback from the judge in oral argument. But we're a long ways from the end line here. If they get through the motion to dismiss, though, then discovery will open up.
Jeremy, before we talk about discovery, can I interrupt you and just set the table a little bit for some of our audience members who may not be in the weeds on what a motion to dismiss means. A motion to dismiss is to dismiss the complaint as a matter of law. But in my experience, and I'd love your thoughts, Jeremy, antitrust cases often clear motions to dismiss because they are very factually intensive, right? A lot of disputes resolve around the facts. So I guess the question, I think it's a fairly straightforward question. Will the courts on a motion to dismiss posture, do you think, give some guidance about what some of the guardrails may be, at least in those judges' views about what the law is on some of these issues?
That's a great point. So in a motion to dismiss, the court has to take the allegations in the complaint as true. So, and there are some exceptions to that where you can bring in some outside information, but basically you've got to assume that the allegations are true. And then you say, the decision is there enough here to let this move forward to try to get to a decision on the merits? When judges issue their decisions on motions to dismiss, though, it depends on the judge, but you do often get a steer on kind of where the weaknesses are, what would need to be proven, what kind of facts would need to be shown, where the plaintiff's weaknesses are. And sometimes the courts do use the motion to dismiss to take a case that's very, very broad and limit it into very focused factors. And I think here, if I were, and you may see the judge kind of dismiss the per se claims and say this is going to be rule of reason. So we may actually get some guidance at that early stage. But I think, as you mentioned, antitrust cases are very difficult to get dismissed because of the fact specific nature of them, the nature of the antitrust laws, um, and the obligation on any motion to dismiss to accept the plaintiff's allegations is true.
Exactly. So I would think that the market is going to be very focused on any decisions that come out of the motion to dismiss process to get any kind of read on how the courts may be thinking about these legal issues, and help, you know, market participants plan going forward.
Absolutely. And I think not just the written decision, but any uh, court hearing, any comment from the judge along the way in a hearing on where there's substance discussed will be interesting and will kind of steer the market.
Exactly.
So I'll finish up here, just kind of, if they get through the motion to dismiss, which, we'll see. I think the plaintiffs are going to be looking for documents in the lender's files and the co-op members' files that talk about, this isn't about saving transactions costs. This isn't about all those great reasons for um, having co-ops. It's about, pure exclusion or pure, creating harm to the plaintiff. And, antitrust cases, um, maybe they're not unique, but they almost always involve pretty extensive discovery, and that will be, and we got a lot of parties here, so kind of digging into the documents and seeing what comes out. If the plaintiffs find documents that show the lenders and the members of the co-op getting together and kind of plotting some kind of hatching some evil plot, kind of creating, using bad words, they're going to be relying on those as they go forward to try to survive summary judgment and try to put pressure on the defendants groups.
As a reminder, it's always important to watch your emails. Sarcasm doesn't play well in court. And, I think that for those of you who said it's too early to tell, you may be thinking of discovery, because sometimes discovery can uncover very helpful or unhelpful documents depending on your perspective.
Excellent. Thank you, Jeremy. That was a very helpful background on the cases and the governing legal framework, and it gives us a lot to think about. But one thing that struck me as you were talking, and as we've thought about these issues for the last 2 to 3 months since the lawsuits have been filed, is that there is a lot of uncertainty potentially in the market, and people. I've joked that the biggest beneficiaries of what's going on are antitrust lawyers, perhaps, because it seems like a lot of people are consulting with antitrust lawyers on these issues. So I'd like to bring in Sean and Dan to talk about, what are we hearing in the market? Are people reacting to this? Are they not reacting to this? So I'd like to turn it over to Sean and then Dan to give us
Sure.
your sense of what's the market doing now.
Sure. Two things. First, let's look at it from the borrower side, and then let's look at it from the creditor side. Ian already talked about the co-op provisions. We haven't seen them clear the market. Optimum is interesting because it's like a 5-paragraph provision, and it says that, first you have to represent that you're not a party to a co-op agreement. Then you have to say that if I become a party to a co-op agreement, then I'm going to forfeit my rights as a lender. And that's a liquidated damages provision for breach of it. And then there's actually a compliance certificate obligation as well, that if there's a transaction or for up to 2 times, the borrower can ask each year whether a lender is a member of a co-op agreement. There's kind of a understandable exception for qualified market makers, and it purports to apply to participations as well. So again, we haven't really seen a lot of those clear the markets, but we're aware of at least 2 of them. On the creditor side, we're actually not seeing people change their behavior, in the sense that people are still forming co-ops. They are still signing co-ops. And, I think that's not surprising, consistent with the poll today. I think that, number one, this is not a new issue. Over the past few years, a number of the debtor shops, you know who I'm talking about, have been saying that co-op agreements violate antitrust laws, whether it's in the U.S. or the UK. So many lenders and creditors have already gotten advice from counsel about whether or not there's a violation of antitrust laws for entering into this. And basically that means that reversing your position now would from an internal compliance standpoint and kind of reporting up would create some tension. Secondly, there's nothing about these lawsuits that really seems to be changing the market's mind. No real new issues are being raised. It was as expected. As I noted, it's been threatened before. I think number three is that nobody wants to miss out on opportunities as a co-op member. Co-op members do get certain benefits, whether it's just being in the room or otherwise. And then finally, I would say that I think people believe that co-op agreements serve a valid purpose to reduce transaction costs, and ultimately reduce borrowing costs and level the playing field between borrowers and creditors, and are completely consistent with one of the fundamental constructs of debtor-creditor relations, which is collective action. So again, we're not really seeing a lot of changes in behavior on the creditor side. Dan, turn it over to you for any additional or different thoughts.
Sure. I'll just add to what Sean said, which is there's sort of two aspects to it, which I think we've tried to emphasize in the webinar, which is one, are co-ops good or bad, which is really kind of the Optimum lawsuit, and then should excluded lenders be included within the co-op, which is really the Selecta lawsuit. And if you think about whether or not co-ops are good or bad, from the Optimum perspective, what I ask myself, and the question I get from people is, ultimately, what is it that they're going for here? What is the real strategy? And what I think is very short-sighted is that on its face, there is this idea that somehow we are still in a world where borrowers can pick off lenders, that we can somehow rewind the clock back 5 or 6 years before we had co-ops and somehow live in that world today. And from my perspective, and I thought it was really helpful to get Ian's setting the table for us, is that what we're seeing with this lawsuit by Optimum is part of a strategy, right? It's the same thing as putting an anti-co-op provision into a credit agreement. It's also the same thing as putting together a DQ list. And all of these are strategies that I think the borrowers believe can help them leverage an outcome with respect to their lenders. And I think what it doesn't take into account, and why I think ultimately these strategies will fail, both in terms of the primary market on documentation, and if we think about the litigation route, is that we live in a world today that's fundamentally different. And I think what the market has learned is that in the context of these LMT transactions, we largely have a very concentrated repeat player market, even in the syndicated loan market. If you look at the CLOs, how concentrated they are amongst the top 10 players. This is not a market in which it's anonymous, where you can easily pick off a lender. And it's also not a market where, and I think the lesson learned by the larger players is that you will not benefit yourself over the long term if you solely look to your own self-interest. You can just look to Apollo or Angelo Gordon, who have found themselves on the outside of these deals. So to me, this is all ice in the winter from the perspective of the borrowers, because I don't think it really gets them anything. Yes, they might be able to point to a precedent when it comes to JP Morgan doing the Optimum transaction. But if you're really talking about the market, which is where the available credit is, the market is ultimately going to go with their pocketbook. And their pocketbook is basically going to mean that they are not going to, over time, cut out other large players from transactions. So from my perspective, it's very short-sighted. On the other side of this, to me, what's interesting is when we think about Selecta, the market is actually moving towards this sort of tiered approach in the context of a good co-op to give additional benefits to excluded lenders, which is essentially, to my mind, what the excluded lenders are trying to achieve in the context of that litigation. And so when I look at kind of the ultimate outcomes in the two cases, to me, and this is probably talking my own perspective, is I do believe that the Selecta type lawsuit, and it's very interesting that the intuition of the people in the market is that it tends to have a greater likelihood of success, is one that is in the same direction that the market is going. So to me, it does continue to level the playing field in terms of that risk reward analysis that the insiders are doing. Is it worth us excluding lenders if we potentially have to look at an antitrust lawsuit that'll allege treble damages or provide additional value to try and level the playing field?
Well, Dan, that raises a really interesting question, and I'd love your perspective and Sean's perspective. If these lawsuits are a reaction to cooperation agreements, and in the case of Selecta, we've got excluded lenders and the like, is this just another tool that we have to deal with in out-of-court restructurings? Are we going to see more of these kinds of lawsuits, or are these kind of one-offs, do you think?
Well, from my perspective, people don't always act rationally. So while I just gave you my rational view of the world, which is it's ice and winter and it doesn't get them anything, we're going to continue to see crafty lawyers with sponsors trying to put DK provisions into credit agreements, anti-co-op provisions in. Ian's going to be very busy reviewing those. And I'm sure we're going to continue to see these lawsuits because there's perceived value in being able to put pressure on your lender group to create leverage. I think Sean's view and my view is that ultimately that really isn't going to come to bear. And it's interesting when you look at that litigation timeline that it's likely that the rubber's going to meet the road well before any of these lawsuits actually get to finality. And, on the other side of the equation, when we talk about Selecta, it's very expensive for excluded lenders to bring that type of lawsuit. It's also very expensive for the inside lenders to defend against it. And so I think you're less likely to see those. Also because I think buying peace is actually something that is relatively cheap to try and get to a consensual outcome in the case of Selecta. That doesn't mean that we're not going to see those lawsuits. Clearly, Selecta, if you look at the trading price, there's a massive differential between the insiders and the outsiders. But it does seem to me that that trend is moving more towards pro rata anyway, and that that's probably a legitimate threat to probably try and get to a more consensual deal.
And hey, Dan, I agree with everything you just said. I think that it remains to be seen, but I would presume that there will be more of these lawsuits, right? We've seen a number of lawsuits that say that LMEs violate indenture provisions, violate the good faith and fair dealing requirements under New York law. We see that in the Selecta lawsuit itself, as well as the Optimum lawsuit. So maybe people will just add this new antitrust cause of action to those existing types of allegations, because we're not going to see anything, I don't think, in the near future, in the near term, before the rubber hits the road from the two cases that are out there in terms of actionable decisions.
Yep, that's a great point, Sean.
And Ian, did you have a comment?
Yeah, I wanted to ask Dan, do you think, especially on the Optimum side of things, is this a Drahi thing? Like, I can't imagine a lot of sponsors wanting to bring these kinds of lawsuits because, again, they often benefit from co-ops. Are they going to cut off their nose to spite their face by doing these kinds of lawsuits that Optimum is doing? And is Optimum sort of unique in that sense because it essentially isn't a large private equity company? It's kind of governed by this one guy who doesn't like his co-op.
So ultimately, the driver of the strategy are the lawyers, right? We can all admit that. But to your point, if you're a private equity player right? And actually, we published a chart on this that showed that, today the largest private equity players are some of the largest players in the debt markets. So if you are a private equity player, I think you are really going to be thinking twice about bringing this type of lawsuit because it could hurt your overall business in a way and have unintended consequences. It's one thing if you're going to argue over the contractual language in a deal with lenders and a private equity deal versus try and blow up co-ops across the market. So I'm curious, Sean, if you have a different perspective. I know that there are some sponsors who are probably just more aggressive and don't have that private credit exposure. But for those that do, I do think that it'll probably be harder for them to get comfortable bringing that type of suit.
Yeah, I think that's right. I mean, there's been a lot of pushback, and I just don't know, if people want to spend the time and energy that the discovery is significant, in terms of cost.
That's great. So I think we're at the top of the hour. I'd like to take, unless Dan or Sean, Jeremy, or Ian, there's anything else that you'd like to say in terms of closing remarks or final thoughts. I'll give everyone a second to say anything, and then we'll thank everyone. Dan, why don't we start with you?
From my perspective, what I have thought is interesting, just been a part of the conversations with people, and I'm actually somewhat heartened to see some of the polls, is that there is a real difference between these two lawsuits. And so from my perspective, the takeaway I would want people to appreciate is not to throw these lawsuits sort of together. They are actually very different. And I think the likelihood and I think the type of arguments that are being made are very different. And I think on one hand, you can believe that co-ops are good and that Optimum's case is weak, at the same time as saying that the Selecta case is stronger and that excluded lenders should actually be included within co-ops as being entirely consistent with the antitrust arguments that are being made. And so I just feel that nuance is one that people are starting to appreciate. So and I think we did a very good job, and hope people take away from this that there are different outcomes here potentially in both of those lawsuits.
Awesome. Sean, do you have any closing thoughts?
Nope, I'm good, and also we're at the hour. So
Okay. Jeremy or Ian, any final thoughts? If not, I'll wrap it up.
I'm all set.
Okay.
Thank you.
Hearing none. First of all, thank you very much to everyone who joined us today. Like I said, this webinar will be available on YouTube in about 24 hours. So you're welcome to share it with your colleagues or listen to the replay or ask Gemini any specific questions about what we said. I'd like to thank our friends at Cleary Gottlieb, Jeremy and Sean, for joining us. It's always a pleasure to have you. Also, Dan, thank you so much for joining us. As always, a pleasure. And Ian, of course, thank you for joining us. Have a wonderful Tuesday, everyone, and goodbye.